Welcome, and thank you for participating in Occupational Health and Safety Act Responsibilities and Rights Refresher. The Occupational Health and Safety Act provides the legal framework and the tools to achieve healthy and safe workplaces. It sets out the rights and duties of all parties in the workplace. It establishes procedures for dealing with workplace hazards, and it provides for enforcement of the law where compliance has not been achieved voluntarily. The Occupational Health and Safety Act was passed in 1990. It had an immediate impact on reducing work-related injuries. The system works and must be respected by all workplace groups. The Act categorizes workplace persons into four separate groups: that of constructors, employers, supervisors, and workers. Each group has their own set of responsibilities and rights. A constructor is a person who undertakes a project for an owner and includes an owner who undertakes all or part of a project by himself or by more than one employer. He or she must ensure that everyone and all work processes comply with the law, ensure all workers' health and safety are protected, and provide notification of project to the ministry. An employer is a person who employs one or more workers or contracts for the services of one or more workers and includes a contractor or subcontractor who performs work or supplies services, and a contractor or subcontractor who undertakes with an owner, constructor, contractor, or subcontractor to perform work or supply services. He or she must provide equipment, materials, and protective devices and maintain them. Ensure that everyone and all processes comply with the requirements of the law. Provide information and instruction to protect workers' health and safety, provide competent supervision, acquaint workers with hazards, and take every precaution reasonable to protect workers. A supervisor is a person who has charge of a workplace or authority over a worker. He or she must ensure that the health and safety of all workers are never in danger, ensure that workers work safely according to the law, ensure that workers use and wear any PPE or clothing required, advise workers on any possible danger to their health and safety, and the supervisor, as an extension of the employer, must also take every precaution reasonable to protect workers. A worker is a person who performs work or supplies services for monetary compensation. He or she must work safely at all times, wear any PPE or clothing required, never remove a safety guard or any protective equipment, report any protective device that is missing or defective, report any workplace hazards, and report any violations of the law. In criminal and civil law, an entity or person accused of causing or failing to prevent an injury or illness is found innocent until proven guilty. In labor law, an entity or person accused of causing or failing to prevent an injury or illness is found guilty until proven innocent. This reverse in responsibility makes the application of the clause take every precaution reasonable to protect workers very significant. The Labour Program of Canada defines reasonably practicable as taking precautions that are not only possible but are also suitable or rational given the particular situation. Exercising a high degree of due diligence is what the Ministry of Labor expects of all workplace groups. If you are unable to demonstrate a high degree of due diligence, you remain guilty. Workplace inspections, equipment inspections, job hazard analysis, and safety meetings are expected to be completed with the participation of all affected work groups. Employers have the right to determine and control work as long as everything is legal. Workers have the power to protect their health and safety. This power comes from the legal rights to know, participate, and refuse. The right to know refers to the right to know about workplace hazards. Employers must provide a wide range of information about hazards to workers, such as training and communications, inspections like workplace inspections and equipment inspections, and a variety of meetings like the job hazard analysis, tailgate talks, emergency preparedness plans, and reviews. The right to participate refers to workers having the right to make health and safety recommendations. It is the employer's responsibility to provide avenues in which this is possible. In your case, HCSL maintains a compliant Joint Health and Safety Committee where workers elect their representative. HCSL has health and safety representatives on sites with 6 or more workers. And HCSL encourages worker participation in job hazard analysis, workplace inspection reports, incident and accident investigations, and a variety of health and safety reviews. The right to refuse refers to workers having the right to refuse work if they believe it endangers their health and safety or the health and safety of others. The matter is investigated and resolved to the satisfaction of the employee and the employer, even if it means requesting the involvement of the Ministry of Labor. In summary, all workplace parties have strict responsibilities and rights towards maintaining a healthy and safe workplace. All workers have the rights to know about workplace hazards, participate in workplace health and safety functions, and refuse unsafe work. You have reached the conclusion of this training presentation. Thank you for participating in this refresher on Occupational Health and Safety Act responsibilities and rights. Please proceed to the test in the tasks section of the training site, and good luck.